start to give us plenty of time. So, Chris, over to you.
Thanks, Angela, and good morning, everyone. Yeah, what's hot and affecting planning at the moment? I think, as probably many of you have seen in the media and just through Amazon Prime, certainly Clarkson's farm is sort of capturing this sort of a microcosm of what's happening in planning at the moment, particularly with the farming community and rural communities. We're certainly seeing a lot of work coming from sort of similar farm sizes, similar to what Clarkson's got. And by that, I mean particularly diversification and what the future of farming might look like. Certainly, the rise in energy costs, feed costs for livestock, increased requirements for ecology, protected species becoming still a big area of sort of restriction for development, are all areas that are affecting farms and sort of rural communities in terms of developing and trying to find ways to basically respond to change. So in terms of how that's coming through to the work we're seeing, particularly in Gloucestershire, that is sort of translating into things like barn conversions, finding potentially commercial premises on site. Certainly the interest from companies to find offices in rural areas seems to be a growing area of demand. Hospitality and tourism. We've recently been working on some interesting sort of hybrids of yurts and sort of shepherd's huts in rural areas to try and find ways to make use of land that might otherwise have been unviable for farmers based on this current context. And other areas including sort of renewable energies, things like solar farms, and even rewilding. We recently secured planning permission for a rewilding project in the Midlands for a farm to essentially plant and work on biodiversity again on part of their plot as part of a subscription service for companies who want to sort of offset their carbon footprint. And so it's interesting to see that that sort of traditional farm model, whilst that has historically been changing over the past few decades anyway, is certainly there seems to be a rapid increase in that, primarily as a response of the impact on viability of farms throughout the country, and the same particularly in Gloucestershire, we're seeing that as being quite a prevalent one. The sort of question that as planners we find ourselves in is that the planning system has never been geared up to move quick or respond in an agile manner. So we find ourselves working quite closely with local authorities to make sure that any application that comes forward that is certainly unique, or trying to sort of find that means of diversification, is responding as best as possible to the policy requirements of the local plan, and certainly how the local authority wants to see rural communities work in the long term. It's trying to sort of avoid those knee-jerk reaction type of applications, rather than trying to find a balance with what could be a long-term solution for a lot of these farms. With that, and sort of on the environmental point, and this covers more towards also development more generally, the Environment Act 21 is coming through and is up for consultation at the moment. The aspect of that that's particularly interesting for planning is that it will include biodiversity net gain requirements, which mean that for future development, you'll be required to provide at least 10% biodiversity net gain on the site. Now, what does that mean, and how does that impact planning? Well, certainly if you're working on a large plot and you've got a lot of land to your disposal, that sort of leaves you in a position where you might have that space to provide it. But we're finding that certainly when you're dealing with tight urban brownfield sites or areas that are just naturally constrained, it seems to be, certainly in our opinion, that it's acting in some extent as quite a hindrance, particularly because it's such a blunt reading of it, in being that it should be up to at least 10% as a minimum. And so we're finding ourselves in a position where, working with architects and landscape architects as well, we're having to be much more agile and creative on how we address that. But it'll be interesting to see how the planning system and certainly the development industry responds to that, to make sure that we hit those targets, but also ensure that development can still progress and meet the housing commercial needs that we're all after, both in Gloucestershire and nationally. On that sort of topic, and this is again sort of tying it back to what we're seeing in sort of places like Clarkson's Farm show, is the impact of community consultation and working with multiple land sort of stakeholders. Certainly we're seeing that sort of the importance of engaging with communities is becoming much more prevalent. People are becoming much more interested in seeing what's happening. Certainly, we're seeing an uptake in public consultations and sort of consultation responses more generally. It seems to be a case that the attention is there, and I'm not sure if that's because of shows like Clarkson's Farm or if it's just generally that people want to be more engaged in how areas are shaped. And a good example of that was when we worked recently with Spirax Sarco on their new office development, which is the image behind me, up in Charlton Kings, where we got a BREEAM outstanding design through with Robert Limerick's architects. And yeah, in that process, there was a lot of sort of balancing going on. We found ourselves sort of working closely with both the local authority. Heritage was a big impact that we had to balance with the impact of local character, and working with also the requirements of Spirax itself, and making sure that that new office environment was something that would work best for that company. So that sort of stakeholder engagement and trying to pull in multiple areas of interest is becoming a part of planning that's growing more, which I certainly welcome. I think it's great to have more people involved in the process, and we hope that that's going to continue. And yeah, the final one really to sort of summarize really from, again, taking it from Clarkson's Farm, was the dangers of retrospective. I think the aspects that sort of underlying and the sort of frustrations I think that Jeremy Clarkson was sort of raising is the fact that a lot of the work he was either doing or had planned he'd done already without consent. And you sort of then find yourself sort of your hands tied if there's parts of it that aren't in line with what the planning system looks for. And so we've had a slight uptake as well in cases where, certainly particularly during the sort of COVID period, where landowners or certainly even homeowners were building aspects on their properties without planning consents and having to sort of maneuver that process, that application through the planning system, and advising them on that, what they might get or what they might have to expect to lose. And I think that the life lesson there from those types of applications is managing attitude to risk, but also making sure that if you are in that position, that you accept a degree of flexibility to make sure that you can respond to how the planners will look at it. Certainly, whilst the planning system appears to be a law unto itself, there is a sort of general structure there. And so part of what we're looking at is to make sure that we're managing applications in that sense. But yeah, certainly it's interesting to note that the interest is there in planning at the moment, and we hope that will continue because, as I said earlier, having engagement from the wider community, be it business or sort of local community, is something we really like to see, and certainly means that schemes like the Spirax Sarco one are a real success story for places like Cheltenham. But yeah, I think that's it from me.
Thank you. Thanks, Chris. Yeah, it's interesting. There's some really good points you made there. And all over the news, we probably heard this morning very much about farming and actually the empty shelves. And, actually my 19-year-old daughter came rushing home yesterday going, "My God, Mummy, there's no fruit and veg on the shelves." So it is a reality. And they're talking about, coming into March when we should be able to have more produce locally. But being an island, it is something that we really do need to think about, is how do we make sure that we have enough produce? And obviously that's hugely around farming. So it's quite interesting that what you're seeing in that area. Does anybody have any questions for Chris around anything on planning that they might like to ask? The sustainability thing is also a really another good point, and it's interesting you bring up Spirax. If anybody is interested in sustainability and what they've been doing, we have got an in-person visit to Spirax Sarco on the 13th of March, and we will be going into not that building but their other building and talking about their sustainability strategy and some of the things that they've been doing. So it's quite interesting that, they are a great example of how they've put sustainability at the forefront. What percentage increase would you say that you've seen, Chris, in businesses really looking at this? Because for so many years, from the construction and property sector, people would ask about it and it was a nice to have, but when it came down to cost, it was something that they were always chopping out. Well, actually, no, that build's become too expensive if we do all of those sustainable options. So are you really seeing on the floor that companies are taking it seriously now?
Yeah, it's a good question. And I think absolutely, I think the big one in particular is the commercial sector, where you've got companies who are really feeling the pain of the energy price increases. And so the response to that we're seeing is companies coming to us asking for what they can do through planning to, for example, take advantage of large empty roof spaces above warehouses to put solar panels in, or find alternative ways to get renewable energy into their practices and companies, to make sure that they can, whilst they see it almost as an investment into their company, as a way to ensure that they can manage those future energy costs. So energy certainly has been a huge driving factor in that. It's also part of the company ethos to try and improve sustainability. I mean, certainly the Spirex Sarco example is one where it's Gloucestershire's first BREEAM outstanding. In other words, it's trying to sort of set the benchmark, hopefully, for future development of commercial premises in Cheltenham and Gloucestershire, as a place to demonstrate that there is an opportunity here to take advantage of sustainability in company sort of facilities, and again, tying this back to the cost saving then comes later on primarily through the energy savings, but also in terms of also creating environments that are genuinely good places to work. I think we're all seeing that again from the work from home culture that came around through COVID, that going back to offices or other facilities to work, we want to make sure those environments are ones that are comfortable to work in and generally are good places to be. And that again is part of the image we're seeing from Spirex, but also from other companies as well, where they're looking at their facilities and reconsidering how they can either improve them from a sustainability point of view, but also from a point that they can make sure that the staff have a place that they can genuinely want to work as well. And as you say, on the farming side, it's one where we're trying to balance from the farming community. So going to empty shelves in supermarkets is always a bit of a shock, really. And we're hoping that that's a short-term one, but it's managing those farms and making sure they stay afloat. Certainly, a lot of the barns we're working with, they're primarily poultry at the moment. There's a lot of farms in that area, particularly with egg laying, that they're just not viable on their own, and ultimately those farms need support, otherwise they're not going to be around to feed us in the long term. So finding those alternative means of income for farms is massively important, and something the planning system has to respond to.
And it's interesting as well how you talked about rewilding again through our sustainability focus events. We were talking about that quite a lot in the last one. How actually nature will provide a lot of the answers around climate change. So doing the rewilding and encouraging more of that within the environment has just got to be a good thing. And also, just as an example, I don't know if any of you know the Market Group, and they've done a huge amount of solar panels for their Premier Kitchen site. And when they first tried to do it, it was the cost was prohibitive. It was so expensive. But then they revisited it again with the cost of energy going up. And they thought that it would take about 5 years for it to actually start to pay back. But because of the high increase in energy costs, it's actually started to pay back within about 18 months, which is phenomenal. So, that they made that initial investment and it's paying back already. So it is something that businesses should really be thinking about. Okay, so if there's no further questions from anybody on that, then we can move across to you, Alasdair. So I'd now like to introduce Alasdair Garbutt. Alasdair's a partner, as I said, and head of real estate at Willans LLP. And Alasdair, you're going to be giving us an update on some changes coming up. Over to you.
Thanks, Angela. Yeah, I'm going to cover quite a large number of changes that are coming up, or in fact have already come into effect this year. Some of them in not a lot of detail, but I think all of them are changes that affect landlords and tenants, generally across the board. So I'm going to look quickly at Overseas Entities and Economic Crime Act, Companies House. I'm going to spend most of the time looking at minimum energy efficiency standards. So hopefully that's slightly tying in with talking about energy, which Chris and Angela have already just done a bit, because I think those MEES regulations will have the biggest impact this year coming up. Then I'm just going to touch on really quickly changes to charities, rates, and finally touch on changes in telecommunication code coming up this year. So I'm afraid updates in law aren't always the most exciting sort of updates that we can give, but I think they are this year actually some of the most important changes that will affect people in practice, landlord, tenant, buyers and sellers. So starting with the overseas entities, the Economic Crime Act came into force 31st January. Yeah. The act was rushed through Parliament in response to the war in Ukraine, and unusually was implemented really swiftly afterwards. So it came into effect, as I said, on 31st January just gone. And the you might think, well, it doesn't apply to really very many people, because you know, we are not, our company is not registered overseas, but I'll come on to explain why it may impact more people than you think. The effect is that owners of companies registered overseas, so beneficial owners, need to be registered, and failure to comply means fines, criminal sanctions potentially, and the inability to complete major deals within UK property. So the effect which we may all see is that if a tenant is taking a lease from a overseas company, or you're buying a property from an overseas company, you won't be able to register that purchase or lease unless that seller or landlord has complied with the Economic Crime Act and registered all the beneficial ownerships with Companies House, because there'll be restrictions on the land registry which prevent that. So it's really important as a first step to, as a buyer or a tenant, just to look that up straight away. It's one more thing for us lawyers to tick off our list. Following that, there is expected to be another Economic Crime and Corporate Act coming up, which will affect all of us, that are all of you, that are registered as companies, because a significant change is likely to be introduced, that it's going to be mandatory for ID to be verified and recorded at Companies House. At the moment, you're probably all aware, you just put in your name, address and date of birth, and that's it. But there is going to be some, or expected to be some, ID verification coming up. So moving on from that, the biggest impact, I think, on all landlords, tenants, buyers and sellers is going to be the MEES regulations, Minimum Energy Efficiency Standards. And these come into effect on the 1st of April. So hopefully everyone's already aware of them. If not, there's a bit of time to rush around madly trying to comply. And the effect of the new rules coming in on the 1st is that it's not just, as it is now, granting a new lease of substandard commercial property that puts a landlord in breach of the rules, but from the 1st of April, it will be continuing to let a substandard property, and that becomes unlawful. Although it doesn't invalidate the lease, so there's no worries about that. So to stay within the rules, let commercial property, so continuing to let it, it must have an EPC, Energy Performance Certificate, of a rating of E or above, unless the landlord has registered an exemption. And there are some quite serious consequences for breach, which I'll come on to. So just to repeat that, it's a requirement to have an EPC of E or above if you have any lettable commercial property. Compliance matters because there are some serious financial consequences. Landlords that let substandard property without the exemptions, I'll come on to the exemptions, are going to be liable for 2 penalties. One's financial and one is called a publication penalty, which is a naming and shaming penalty. So the financial penalty that could be imposed for letting non-compliant property, firstly, it falls into two categories. It's lesser for letting a property for less than 3 months. That's 10% of rateable value penalty, with a minimum of £5,000 and a maximum of £50,000. And that applies on a letting of less than 3 months, as I just said. For a letting of non-compliant property of more than 3 months, which would normally be the case. I mean, I haven't done a commercial letting apart from some sort of short license for less than 3 months for ages. The fine for longer than 3 months is 20% of rateable value, with a minimum of £10,000 and a maximum, which you won't believe, £150,000. So obviously seriously significant fines, and it's likely therefore to make the costs of doing the work less than the potential costs of the fines. So serious consequences have to be considered. The naming and shaming aspect maybe won't be as worrying for everyone, but for portfolio landlords, for example, who have like to have a good reputation in their either national market or local market, there could be some serious adverse publicity that comes out of that as well, which means future tenants may not want to let property from that landlord. So that must be considered as well. So exemptions, which no doubt you're all on the edge of your seats waiting to hear, do apply to commercial premises, and you can continue to let a substandard, so less than E rating, without enforcement action being taken. I'll just quickly nip through a couple of these. There's a 7-year payback exemption. So if the expected savings on energy over 7 years are less than the cost of improving, then you can have an exemption for that. And there's a government test, I believe. I haven't looked into the detail greatly, and you'll no doubt need a surveyor and a qualified person to deal with that for you. There's a devaluation exemption, where if a surveyor's report confirms that the installation of the energy efficiency measured would devalue the property, I think by more than, or by 5% or more, then you're exempt. And exemptions last for 5 years and they have to be reapplied, and you have to register them with the government register as well. Some good news if you're buying a property subject to tenancies as well is that there is a 6-month exemption period to allow the buyer, new landlord, time to deal with the issue. But it is obviously a serious consideration when buying commercial property now, that you must ensure upfront as part of the due diligence that there's either an exemption or the property is rated at E or above. And I would suggest you surveyors out there will probably be considering that in your valuations on purchase prices. And just finally, a quick point on landlord and tenant relations. This is also going to impact on those negotiations, and also on us lawyers' lease drafting, because there is another exemption which could be quite useful, in that if landlords can't do the work or can't inspect the property because they don't have the rights to do it, or for instance a mortgage lender refuses permission, then there is a third-party consent exemption, as in if you can't actually get the consent to do it, you can be exempt from MEES for that provision. So quite a lot to take in there, and as I said, hopefully a lot of you are going to be up to date already on that. If not, seek help from surveyors and lawyers. couple of the other things I mentioned, I'll just briefly mention, which are being updated this year, is charity land. We at Willans have quite a large number of charity clients, including national charities, where we act on all of their property. And likely coming up shortly, there are going to be changes to the Charities Act, reducing burdens on charity disposing on property. At the moment, there are a few hoops to jump through, including getting surveyors' reports. That's likely to change. Next point, business rates. In case you didn't know, the current rating list closes on the 31st March 23. So the final date for appealing those rateable values is 31st of March next month. And finally, I was just going to mention telecommunications code. A few of our clients are landowners and have mobile phone masts. Also, one or two clients have masts on their commercial properties here in Cheltenham. And there's going to be a significant update to the electronic communications code later this year, which will, well, in short, be in favour of the telecom companies rather than the landowners, dealing with giving the operators more rights for upgrading and sharing equipment, how to deal with unresponsive landowners, because a lot of things have just been left lying with landowners refusing to deal with the operators. And then there's going to be more clarity, I believe, on aligning the renewal processes for the telecom masts and the like. So quite a lot going on, and as ever, seek advice about your specific circumstances.
Thank you. Yeah, thank you, Alasdair. We have got a question in the chat for you. So if they have a current EPC rated F, do they need to carry out the works and have a new EPC commissioned to demonstrate the new rating before the 1st of April? And that was going to be one of my questions. Is the ruling coming in of the 1st, you have to have it done by the 1st?
Yes, I believe so. Yeah.
So you have to have the work carried out, and you have to have a new certificate by the 1st of April.
Well, that follows, because from the 1st, if you're continuing to let a substandard property, then that becomes unlawful.
Right.
So if that question is yeah, it means you have if that question is from a landlord who's letting out property that's F, you either have to have an exemption or be E or above by then.
Wow, so there might be a lot of very busy surveyors and very busy builders.
Well, I was going to
get them already, so I don't know how you're going to get that booked in a month.
But what I was going to say in practice is, I mean, I've never heard in my practice as a lawyer, a local authority enforcing MEES currently against substandard property on a new letting. I'm not saying you should ignore the law, absolutely not. That is the case. Well, I've just explained it. But what happens in practice may be different than what the law says. It may be on the 2nd of April, local authorities go around rubbing their hands thinking, great, who can we fine? We need some more money.
Yes, that's
I don't know what's going to happen in practice.
No, that's always the issue, isn't it? Because sadly, when there's a way for them to make money, and that's a lot of money that they could make relatively quickly, they might jump on the bandwagon to get that as a new revenue stream. Okay, so quite a lot to consider there. I am interested actually from the group is, were people aware of that? Are people actually onto that already? And actually, have they done an evaluation? I'm interested in any of you, if you've got a portfolio of property, if you were already aware of that and you're on it, because if you've got some old buildings, typically they probably, unless you've done some work, won't naturally fall into an E or above. So has anybody got any comments on that? So a Web is struggling to get instruction from the client on how and now scrambling to get works quoted for and carried out. Yeah, I can imagine that there's going to be a bit of a last minute rush on that. So yeah, and I should imagine again, you know, correct me if I'm wrong, but you know, I don't know what you may see, John, you know, as architects at Apex, you know, do you see a lot of the older buildings falling under the E bracket, or are they typically now, most buildings, are they over the E or above?
Yeah, hi Angela. Yeah, a lot of old building stock will certainly fall into E or worse. I believe within the residential sector, listed property is naturally exempt anyway, so I'm imagining that's going to be the same for the commercial sector. It's probably going to be one of those things that, you know, it's been in the making for quite some time, but the reality is now, like Alasdair's alluding to, there'll be some people that it's coming to their attention a bit too late, and there'll be this sort of mad rush this year, but it won't all be done before April, we know that. And I think Alasdair's alluded to the fact that, yeah, the local authorities may not kind of have capacity to go chasing down fines, but the natural pressure will be there, as stated in law, that those landlords have an obligation. So I'm sure that there will be a lot of work to come from this for sure.
Yeah. Yeah, no, and I think, you know, a good point there, lots of quite good points actually, Alasdair, thank you for that. I mean, the law isn't always the easiest thing to scramble your way through, but again, if you are looking to buy properties going forward, there's some really useful nuggets and gems in there to make sure that, you know, you've got all the paperwork and you've got all the accreditation and everything. And that's just on commercial properties, Alasdair, yes?
Yes, I'm just talking about commercial. That's my area.
Yeah.
Although, as John said, yeah, there are some similarities with residential, but I'm not in
that. Do you have any idea what percentage of properties might be out there that do fall under the E? I mean, the size of the problem. Do you have any? Does anybody have any insights into the size of that problem? No.
I think there'll be a lot, but of course, if it has been for quite a few years now, the case that you have to have an EPC on a new letting. So most commercial landlords would have that EPC by now, and certainly would have an existing one. So
if you've been renting something for a long while, it's worth maybe just revisiting that. Okay, good. Right, well, some very interesting thoughts there. So we've got here, somebody's just come in the chat. For residential properties, the minimum rating is going up to C from 2025 for new lettings. And there's already some advice going out there for clients with large residential portfolios to keep this under review. So it is useful to know what is also coming your way so that you can plan that into your strategies. And obviously then Chris has come in with he understands that listed buildings are exempt, but only this does not you know, obviously affect, you know, the character and the appearance. So to assume that listed building owners will want to still visit this. So yeah, I mean, obviously from a listed point of view, you are restricted on what you can and can't do. But if you can be doing some energy efficiency, then clearly they're going to want you to be doing that. And, you know, I guess it makes sense as a country, we've got to get better at saving energy and be more energy efficient. But it's the timelines that are always interesting that spur us on to do things. So thank you very much, Alasdair. And again, if anybody goes away and thinks of anything, I will be sharing the details of that. So our final speaker this morning, we've got Nick Southwell, who is also a partner at Willans LLP. And Nick's going to be talking about nuisance claims and to give you some updates and insights and hopefully not too many of you having nuisance claims, but typically they are about, sadly. Over to you, Nick.
Thanks, Angela, very much, and good morning, everybody. As Alasdair already said, legal updates are not always the most exciting part of people's professional lives, but they can be relevant, and I hope some of these may be relevant today. So what I propose to do is just have a very quick overview of the law of common law private nuisance, just as a recap for those of you who don't know a great deal about it, and then to briefly discuss a couple of recent cases which have been through the senior courts this year, which are quite relevant in both residential and commercial settings, as they've appear on the face of things to extend the scope of nuisance claims, which may be of interest to developers or architects or anybody else come to that, because it's something which is worth bearing in mind when advising clients and considering development and so on and so forth. So starting with common law private nuisance, well, there are three types of nuisance which commonly come up before the courts. Firstly, it is where an adjoining property owner encroaches on a neighbour's land. That's as straightforward as it sounds, really. The second element would be where there's direct physical injury to a neighbour's land, i.e., for example, if the land is damaged by commonly tree roots, which may result in subsidence and so on and so forth, or Japanese knotweed, which is one of the cases I'm going to come and talk about in just a minute. And the third element, and the third common type of nuisance, is where there's interference with the neighbour's quiet enjoyment of land, and that can arise in circumstances where, for example, an adjoining owner is carrying out development, and there have been cases where lengthy building works can give rise to nuisance if they go beyond what is reasonable in the circumstances of the case. And I'll come on to talk about briefly what a court considers when determining whether something is a nuisance and how it should be treated as being reasonable or not. So the ambit of private law nuisance it is usually caused by a person doing something to their land which they're legally entitled to do, but which wrongly interferes with the ordinary use and enjoyment of neighbouring land, by, for example, causing physical damage or interfering with their quiet enjoyment and so on. The damage or interference has got to be substantial or unreasonable, and it can arise from either a single incident or indeed a continuing state of affairs. It's important to note it can also be caused by inaction as well as a positive action taken by the adjoining landowner. So where a landowner is aware of a nuisance continuing, and it is important to note that they need to be aware of it, but do nothing about it, then that can give rise to a nuisance as well. So there's a rule which I'll come on to briefly mention, which is about whether a nuisance is reasonably foreseeable. If, of course, the adjoining owner didn't know it was continuing, then they can't be held liable for it. But from the moment they're on notice of it, then it stands to reason that they're on the hook, and when steps are taken requiring them to abate that nuisance, if they don't do so, it can give rise to claims. As I've mentioned, there's no liability in nuisance for damages which is not reasonably foreseeable. So that tries to limit what can or can't be claimed. It has to be something which is linked to the nuisance. If, for example, you're seeking damages for an element of nuisance, perhaps because you're unable to use the property the way you want to use it, but that the other owner had no idea or no way of knowing that that was how you were intending to use your property, then you can't claim damages for that. So it has to be something which the adjoining landowner is aware could give rise to damages. Remedies for nuisance are either damages to compensate you for the loss, or compensate the landowner for the loss, or injunctive relief to require the defendant, that's to say the adjoining landowner, to abate the nuisance and to prevent its recurrence. So it's fairly obvious what that might include. If one looks again commonly at something like a tree root claim, it would be necessary to prevent the roots from continuing to encroach on neighbouring land, which again commonly gives rise to claims for subsidence, which, as any property experts will know, can be extremely expensive and indeed difficult to put right, and gives rise potentially to other losses, for example, increase in insurance premiums, which can be recoverable in circumstances as damages as well. So what does a court look at when considering whether a nuisance is or isn't a nuisance. And the answer to that is that they undertake, in every case, depending upon the circumstances, a balancing exercise, weighing up the various factors, having regard to the overarching principle of reasonableness of the use of land by neighbouring owners. So those factors and the exercise in considering those factors includes looking at the location of the properties. There was a very famous case some years ago by which the court held that a nuisance in Belgrave Square is not necessarily a nuisance in Bermondsey. So it was rather an old case there, and I suspect the law may have changed slightly, but it highlights the point that there are some areas where a nuisance may be claimed where it wouldn't necessarily arise in other areas. The time of the nuisance is also relevant, whether it occurs during the day or at night. If building works are only occurring between 10 a.m. and 4 p.m, then it's likely to be held that that is something which the ordinary and reasonable landowner should put up with in the ordinary course of life. If, on the other hand, they're continuing throughout the night, or whatever it might be, whether it's building works or indeed noise or whatever it might be, then that's more likely to give rise to a nuisance. That follows into question of duration. Again, something which happens for quite a short period of time is much less likely to be a nuisance than something which is prolonged and disturbs individuals for a long period of time. I've got an ongoing case at the moment which involves an individual who owns a residential property next to a development site, actually in Cheltenham, where the building works have been going on now for 18 months and have caused substantial nuisance to her. And the defence put forward by the other side has been one of reasonable user, which I'll come on to, which essentially they say is, no, this nuisance goes no further than what you should have to put up with in the ordinary course of life. In fact, we say it goes much, much further than that. It creates considerable vibration and noise throughout the property. It's damaging the property. It's upsetting the occupiers, and it's too invasive as to be something which you should ordinarily have to put up with, so that it's simply interfering with quiet enjoyment of land. The frequency and intensity is another factor, as is whether or not a claimant is hypersensitive. The hypersensitivity of a claimant is not something which is taken into account in these circumstances. So if you're considered to be hypersensitive and it's judged on the basis of a reasonable bystander, the court will say, well, no, I'm afraid you simply have to put up with that. And the other factor a court looks at is whether or not the nuisance is malicious. If it's held that a landowner is simply acting maliciously and doing whatever it is they're doing, then that can give rise, or rather that then changes the balancing exercise when determining whether a nuisance is happening or not. In terms of defences, I've mentioned reasonable user, and that comes into this business about the balancing exercise. The defendant to these claims is going to say in most cases, well, actually, no, it is not unreasonable to carry out building works, or if you live next door to a restaurant, to have to put up with some degree of odour from the restaurant whilst they're during cooking hours, or whatever it might be, or a bar or a club where there's music. In those circumstances, that would be a degree of reasonable user. But whether or not the use is reasonable, it is tested against the standard of whether an objective bystander would consider it tolerable or not. And frankly, it's quite difficult to really determine which way a court might go. These cases aren't brilliant in that regard, because what is an objective bystander? Fundamentally, it comes down to the opinion of a judge on the day. Planning permission is not a defence to claims. So just because a party has planning permission to carry out a development or work or change of use or whatever it might be, that doesn't give rise to a defence. That's simply a matter for the planning authorities, and you need to consider the nuisance independently. And the other thing to say is that an instance of one event is less likely to create or amount to a nuisance than a continuing series of events. I mentioned earlier that a single incident can be a nuisance, and yes, of course it can, but actually by and large, what the court looks for is whether or not the nuisance has continued over a period of time, so as to determine whether it is a nuisance or not. The cases I want to look at specifically involve, firstly, Japanese knotweed, which of course is a bit of a thorny issue for landowners, because of the damage it can cause to property and the inherent difficulty in getting rid of it, which I'm told, although I'm no expert myself, it is an extremely expensive and time-consuming exercise, and can be very difficult to achieve, even if you go to the trouble and expense of trying to get rid of it. And the other element, the other new case, which has been quite widely reported in the news, involves overlooking, and whether or not homeowners who are overlooked by a neighbouring property, that can give rise to a claim for nuisance, which historically it hasn't, but the new law appears to have extended it slightly, and I'll just touch on that in a minute. So dealing first with Japanese knotweed, the first sort of big reported case on Japanese knotweed came through the courts in 2018, I think it was, involved a case between Network Rail Infrastructure and Williams and others. In that case, the judge on appeal made clear that the categories of nuisance, which I've touched on at the start of this, being encroachment on lands, direct physical injury to land, or interference with quiet enjoyment of lands, are just examples of violations of property rights, which are at the heart of nuisance. But they suggested that the proposition that damage is always an essential requirement of the cause of action is not necessarily correct. And this is quite important, because with something like Japanese knotweed, the damage may not necessarily have happened at the time of the claim. And they went on to say that the concept of damage in that context is elastic, and inaction can be enough to give rise to a cause of action, and hence make up a claim for damages. In that case, what was claimed is that the mere presence of Japanese knotweed on neighbouring land was sufficient to reduce the value of the adjoining property, and that was claimed to give rise to a claim itself for damages. The court dismissed that contention, much to the gratefulness of most property owners, and said, no, that's not right. That's not actionable. That's to say, the mere existence of Japanese knotweed on neighbouring land is not actionable per se. However, the presence of tree roots or rhizomes, I think they're called, if you can demonstrate that they're on your lands, even if no actionable damage is being caused at that time, would be a nuisance. And so you can claim in those circumstances, or you could claim in those circumstances, damage to abate that nuisance, whatever steps that might be, whether it's to prevent the nuisance from continuing by removing the roots and so on, or anything else. But that's where it stopped. And the new case, which has come this year, which is the case of Davis and others against Bridgend, goes slightly further than that. And what that states is that where there's been an encroachment on neighbouring lands, where there's been an encroachment of Japanese knotweed onto a party's land, then there has been a physical interference with the claimant's property, and consequential losses, which include diminution in value, can then be recoverable. So that goes a bit further. So whereas before it was held that diminution in value was a pure economic loss and therefore was not recoverable in these circumstances, the court will now find that if you can show the presence of Japanese knotweed on your land from the adjoining property, then even if it's not actually causing damage to your property, you can still claim damages, not only to prevent the nuisance from continuing, but also for diminution in value of your property going forward. Now, that's not an easy exercise and would have to be determined by valuers and surveyors. And the saving grace for defendants is that actually obtaining that evidence as to diminution in value is quite difficult. So we don't yet know what effect it's going to have, but it does extend the premise of how damages can be calculated in these circumstances. And so where you're dealing with clients, whether they be residential or commercial, where Japanese knotweed is discovered on their property, the importance is then trying to determine where it is, and from that point on, putting them on notice potentially that they need to take steps to prevent it from encroaching on neighbouring land, because that could then give rise to claims. Whereas before, the extent of the claim would essentially be to prevent the nuisance from continuing. Now, the extent of the claim can be to prevent the nuisance from continuing, and also to pay damages to the other side if they can show that their land or property's been reduced in value, and that's quite a significant change in the law. The second case, which has been quite widely reported and has perhaps been slightly unfairly reported in the sense that it involves extremely prosperous landowners who some people would say don't deserve the protection of the courts in quite the same way as others, but it's an unreasonable proposition in many sense, involves the case of Fern and others against the Tate Gallery and the Tate development scheme. And the case involved a development in London of a luxury bankside development, which was built adjacent to the Tate Modern, both properties being developed at the same time. And at the Tate Gallery, on the, I think it's called the Blankneck building, contains on the 10th floor a 360-degree panoramic walkway showing wonderful views of the city. And the owners of the adjoining properties were concerned because the effect of the walkway was that visitors to the gallery could go out and look down and see straight into their properties through their floor-to-ceiling luxury glass windows, which afforded them the same view of London as next door. And their view was, well, that impacts on our use and enjoyment of our land because we're being overlooked and it's not a reasonable use of land. And at the first instance, the judge felt that they were being too sensitive and that it was the normal use of land, and therefore they couldn't have the remedy they sought. They should simply have to live with the fact that they're overlooked from time to time. The Court of Appeal disagreed. They said that the case wasn't about any undue sensitivity in this case, and neither were the remedial steps which were proposed by the judge at first instance. And the judge had suggested installing different types of glass so that people couldn't see in whilst you could still see out, and so on and so forth. The Court of Appeal judge says, no, that wasn't unnecessary. The issue was the impact of the viewing gallery on the amenity value of the flats, and that once it was established that the viewing platform had caused a material damage to the amenity value of the flats, then the use of the I'll start again. Once it had been demonstrated that the viewing platform had caused material damage to the amenity value of the flats, and that the use of the flats was ordinary and reasonable, as was not in dispute, in the sense that the owners of the flat were simply enjoying their flats as they were entitled to do, but the use of the flats was ordinary and reasonable having regard to the locality, then there would be a liability and nuisance. This comes back to that case I mentioned earlier on, where in this case the locality is an extremely smart part of London, whereas whether the same would apply in other developments, one's not quite sure yet. But the requirement then was to take steps to prevent the nuisance from continuing, and the Court of Appeal did grant an injunction to prevent partial use of the walkway so as to prevent the overlooking from continuing. The case is interesting because in nuisance claims, we've never seen a case where overlooking per se and sort of with that a breach of privacy can give rise to a claim in nuisance, and that's what appears to have happened here. Now, this could cause significant concerns to developers because it seems to be, on the face of things, just another barrier to developing in populated areas, as it would essentially and effectively require them to compensate neighbours, as they already do in case of any other infringements, such as rights to light and so on and so forth. So it extends that potential range of problems when it comes to developing neighbouring property, if there's any prospect that that development could give rise to claims in overlooking. However, I think it probably is a bit tighter than that, in the sense that developers can take comfort from the test that the court applied. The Court of Appeal, or rather the Supreme Court, confirmed that the test was whether the land was being used for a common and ordinary use. And while the Tate's viewing gallery failed that test, it's highly likely that ordinary residential and commercial developments wouldn't. It's difficult, therefore, to imagine that the result would be widely replicated, although I think there's a question of watch this space, and it's just something one ought to be considered when considering developments which could potentially give rise to issues overlooking other property. I don't think it would arise, for example, in the ordinary course of overlooking a garden, which of course would be of great concern to people, but it might be altogether more serious if you were looking into developments and you were looking into parts of adjoining properties which could impact the use and enjoyment of that property in a more substantial way. So, for example, if you're overlooking a block of flats and you can see into potentially see into bedrooms and living rooms, that then it goes further than simply looking into a bathroom, or not a bathroom, I beg one, a garden or something, which could which is altogether perhaps less serious in the overall scheme and would have less potential to interfere with your use and enjoyment. But nonetheless, the case does demonstrate that the courts are prepared to sort of review the law and extend it where necessary, where it can be shown that proposed use is not reasonable and does have the effect, as it did in this case, of interfering with quiet enjoyment of the land. And it can give rise to quite difficult and problematic remedies for people who are developing adjacent land, which could result in them having to change plans and so on and so forth. So it's something worth bearing in mind for any developer who's or architect come to that, who's helping a client in the course of preparing plans and so on, just to take care to have a mind of what the adjacent land is and what it's made up of, and how any potential development might impact upon that.
And just try and avoid even, you know, disputes and if and where possible, just like you say, be aware of these things and avoid these things. So many things to consider. Gosh.
Well, it's some of these things are so abstract that they probably don't arise, but they are just things to consider. And in the course of you know, using land, it's something which parties just should take in, have a care to think about. And I think also, as you say, Angela, part of it, and actually you mentioned this, Chris, the issue really is consultation. If you, in the course of thinking about planning and so on, consult with people and put people in the knowledge of what you're proposing to do, you're less likely that these problems will come up, because people will they'll feel more in the picture of exactly what's happening.
I've got a couple of questions for you. So one of the people on today is asking, they'd be interested to hear your thoughts, is what would you consider beech tree seed pods falling onto a neighbour's land? Would you consider that as a nuisance? So a client that they've got is in that situation. So a neighbouring property, which is a recent new build with beech trees, you know, they've got obviously the beech tree seed pods potentially falling over. And that beech tree's been there for a considerable amount of time, for many years prior. Do you think that that's a claim of nuisance?
Historically, falling leaves are not a nuisance, and beech tree pods, I think, would be included in that, because it's a self-help remedy. You go around with a brush and sweep them up. So as a rule, no. That being said, overhanging branches which come over boundaries can be a nuisance, and there's a duty on landowners to ensure that said branches aren't going to fall, and they can give rise to claims in trespass if they're interfering with light and so on and so forth. So the answer, I suppose, hedging one's bets a little bit, is yes and no. There is the very presence of leaves or seed pods and so on from adjoining land is not itself a nuisance. The landowner would simply have to put up with that. We all have trees in adjacent, well, we don't all, but many of us have trees in neighbouring gardens. They shed leaves and you sweep them up. That's the end of that.
Okay, thank you. Hopefully that's answered the question. And finally, John's asking is, do you see the Fern Tate impacting future planning legislation with regards to private amenity gardens and general overlooking and spreading distances between dwellings, etc.? So you kind of sort of touched on that, but is there anything further?
I think not, John, is the answer to that. I think that would be too prescriptive, and I don't think that was what they were intending when they came to this ruling. The key is to look at what is reasonable, and I think the courts will be very, very reluctant to go further than quite a tight prescriptive interpretation of the current law, so that the simple development, which may then result in being able to overlook a garden and so on, will not be an interference with quiet enjoyment of land.
Okay, thank you so much.
I think. I mean, I may be wrong, but that's not what the intention, I don't think, of the most recent decision is. And if it went back to court, the court, I think, might well be more prescriptive in the way they've applied it.
Thank you for that. And again, as I say, I'll connect you all up, and people can share details, and we'll connect you on LinkedIn as well, so you can stay connected with this group of people. So we've